Moolala is brought to you by the nonprofit credit counseling agency Credit Canada. Are you sure you want to send that text message? Are you sure you want to send that email? You can kind of picture a family lawyer hovering over your shoulder, asking that question over and over, given some of the risks that might be related to when you put metaphorical pen to paper. Our next guest says she is seeing an increase in digital evidence being used in court cases, in divorce cases. Laura Paris is an associate at Shulman and Partners, and she joins us now from Bolton, Ontario, to talk a bit about how technology is coming into play in divorce. Hello there.
Hi, how are you?
I know that this makes logical sense, but I do have a hard time wrapping my mind around it. Can you give us some examples of things that you have seen or that's in the literature or your colleagues have seen that might surprise us in terms of where technology and digital evidence is being used?
Yeah, so I would say the primary place we are seeing this evidence being used is it's almost a corroboration of what we used to see as he said, she said evidence. So in a lot of cases, you have clients come to you and they tell you, certain stories that have happened, and you go and you address it with the other side and they say, that's a lie, that never happened. Now, this digital evidence, in a lot of cases, people follow up arguments with text messages. Or the arguments occur through a text message, or whatever topic they're discussing. So this digital evidence is now almost being utilized as a corroboration of what we used to refer to as he said, she said.
So I think about all the platforms that I'm sending communication on. Is it the gamut? Is it text, Facebook Messenger, Instagram Messenger, WhatsApp, email, LinkedIn? Is it the whole thing?
It really is, can be anything. There's not, when we're talking about admissibility of this type of evidence, it doesn't matter what platform it's happening on. Obviously, you have to be, mindful of the fact that as much as we have, risen with our technology and our technology has become more advanced, that we can utilize this type of evidence, so has our ability to manipulate this type of evidence. So you do have to take everything that you receive from your client with a grain of salt and understand the fact that there is different weight that might be given to it, especially if something is still being disputed. But where we're gathering this information from, nothing specific. Usually it's the main form of communication between the two spouses, though.
Now, the source of it could be the partner sends it to the other partner, therefore they have a copy of it. I probably watch too much TV. What could be subpoenaed in a divorce case? So a message that someone texted to their best friend that you might have heard about or thought about, but that you do not have in your possession. Can the judge require that to be released?
Absolutely. So it really depends on what the information is and how does the individual who's requesting the information know that they're going to gain that certain piece of evidence from having access to that platform. So it's not something that's necessarily commonplace. The threshold in order to obtain that information and have it put before the court is quite high. You do have to demonstrate that it is going to be very helpful to the case. And sometimes that's difficult, especially if you don't know what it is that you're actually looking for or what you're going to uncover once you gain access to that platform.
Can you give me some examples of what would be relevant information? Because I think there's, a lot of horrendous things that people say to one another, either in person or on text, some of which would be relevant in a divorce case, and some of which would be, no, you're just being rude and mean, but it's not material to the case at hand. What would be some examples of what would be relevant?
So where we see this evidence coming up most frequently is in parenting disputes, and often in showing that parents have difficulties communicating. So let's say, for example, parents are trying to have a conversation about which school to enroll a child into, and that conversation, as a result of one party, ends up turning into a bashing, and it turns into an argument because the conversation isn't able to remain child focused. We use those those conversations and multiples of them to demonstrate to the court that the parties are not able to communicate effectively in the children's best interest, and therefore it should be the decision-making power should be given to one parent over the other.
What about as it relates to financial circumstances? And, in the olden days, there was a higher likelihood that one partner could hide assets away. Maybe that's more difficult now. But if you then put up an Instagram shot of this amazing vacation in Cabo and you're claiming that you don't have two pennies to rub together, is that something that would be relevant?
Absolutely. So something like that could be used to demonstrate lifestyle. So if someone is claiming that they aren't working, or that that they're earning an income that's much less than what is believed, we will then do a lifestyle analysis, and part of that lifestyle analysis would lead us to seeking to gain access to social media and of some sort, if we can, obviously using the right measures to do so, but gaining access to that to see if we can do a lifestyle analysis. That even is same if someone is claiming, for example, that they can't work for whatever reason, that they're unable to work, yet we see them, or that they're disabled in some way, and then we see them playing volleyball, for example, and they're saying they can't work because they have an injury. So certainly it could be used in that circumstance as well.
I can see for two people in the throes of a divorce that their lawyer would say, listen, you have got to be very, very cautious on this. But for those who are not at that point yet, at what point do they need to start exercising caution? How far back can things go? Can you dredge up text messages from the super delightful happy days and have that be relevant in a divorce case?
So not really. It really depends. I mean, if you're showing a pattern of behavior that is continuing post separation, then it can be relevant. But for the most part, what happened, even 2 to 3 years preceding a separation is not going to be relevant to a court, and they're not going to be too concerned with it. But with that said, there could be some messages, for example, that talk about finances that now, all of a sudden, as a result, at the time of separation, don't appear to exist anymore. So it really depends on the context of what you're utilizing, because it could be relevant if it's from the past. It really depends. There's a multitude of situations where we can utilize this evidence.
What would be your, I don't know, 3 to 5 guidelines that you would give to a client in terms of the mode of communication that they choose? What's the tangible advice that you say that can go in a text?
Yeah.
All of that, verbal only, and preferably you just keep your mouth shut.
So a lot of our clients, unfortunately, don't communicate well over phone. And I actually try to encourage maintaining communications in writing, because it's black and white. We can't have any interpretation of how those conversations go because we're seeing it. What we actually utilize is these third-party apps. For example, something called Our Family Wizard, which is something where parents communicate on, and lawyers and judges can gain access to that form of communication. So something like that in high conflict cases can be very, very helpful. The main thing that we say is just stay focused on the topic at hand. Don't try to go over and above. Don't get into arguments. Just stay very professional, as if you're having a work conversation, not a conversation with a spouse. And when it comes to social media, I usually tell people stay off of it. Even if there's nothing that is on social media that actually relates to your case, what could happen is it could bother the other person and exasperate the conflict in your case. Let's say if you're posting with a new spouse. So something like that is something to consider as well. When you're going through this, just stay off of it.
You are paid to represent one side of the couple, not both, but one side of the couple. What advice do you give them in terms of what they should retain? So if they receive something, where do they store it? Do they screen grab it? And what would you say they should tell you about if they receive a message that is like this? How does that factor into the work that you do?
So first, we try to ascertain what our clients' goals are. And if we know that our clients' goals, for example, are to retain sole decision making, for example, as it relates to a child, what you want to do is you want to tell them to focus on either finding conversations or taking note of conversations where there's difficulties in terms of communication. When it comes to, child custody or sorry, parenting time, for example, if you're concerned about a parent's ability to parent and you have, for example, social media posts that show that they're with the child and they're drinking, for example, that's something that you want to take note of. So we assess each case on it pretty much on its own merits and based on the issues that we're dealing with. And then we guide our clients once we know what their goals are and what the issues are that we're going to have to deal with through the course of our retainer.
Really interesting stuff, and such a cautionary tale for people as they move through what is already an exceedingly difficult process. Laura, thanks for your time today.
Thanks so much.
Laura Paris is an associate at Shulman and Partners, and she was here to talk about digital evidence and the rising use of that digital evidence in divorce cases.